here with Avi Bell, a professor of law at the University of San Diego and also at Bar Ilan University in Israel. Professor Avi is teaching a short-term course here at Direitos SP, and we're going to be talking a little bit about his major fields of interest. So, Professor Avi, tell us a little bit about the work you do related to intellectual property.
So I work mainly in intellectual property in the area of copyright. But I do property in general, and so I do a lot of things related to property theory, the way intellectual property works together with other fields of property. I also do a little bit of international law and international trade, so I also do some things related to international intellectual property.
Mm-hmm. Okay, great. So you mentioned you do some copyright
yes.
law. And we're currently discussing the reform of the Brazilian copyright law. And one of the big things academics have been discussing is the possibility of the introduction of a fair use-like clause. Could you tell us a little bit about the fair use doctrine, how it works, the 4 steps?
Certainly. Actually, Israel just had a reform of its own copyright law where it adopted the American fair use standard. It's almost word for word a copy of the American law now. So we'll see how this sort of change works in a different country. But the United States has had a fair use doctrine in copyright for about 150 years. And so the fair use standards that we see around the world, they're based on the United States standard, and it's still it's only about, as far as I know, something like half the countries have fair use, and the rest have more localized defenses for particular kinds of acts. But what fair use does is it says it's a very general defense. It says even though you have done something that otherwise infringes on copyright, it's permissible for you to do this without paying the copyright owner, as long as the court is convinced overall that the use is fair. And the court's supposed to look at 4 factors in order to decide whether the use was fair. The purpose of the use, the kind of work that you've been infringing, the effect on the market of your use, and now the 4th factor is eluding me, and the amount of the original work that you've taken in your use. And it's very difficult to figure this out mathematically. Courts have, over the years, looked at different kinds of things. These days, courts tend to look at whether the use transforms the original. So, for example, if the original was a work of music, if the so-called fair use makes a parody of the original and makes the original music into a joke, then that would be considered a fair use because it transforms it. Now that's the way it works in the United States, and that's now the way it's supposed to work in Israel, and we'll see if it works here.
Okay, it's nice that you mentioned parody. Students sometimes get confused between fair use and exceptions and limitations to copyright. Is fair use an exception to copyright? If you could enlighten us a little bit on that topic.
Sure. Fair use is phrased in the law as if it's an exception. That the rights of the author are very, very broad, and they include these exclusive rights to copy, to make derivative works, to distribute, to perform for a very long time, for a lifetime plus 70 years, or sometimes up to 120 years. And fair use is just listed as one of the possible defenses or exceptions that may apply to someone who uses without permission. But in American law, it's not seen that way. It's seen as much broader than that. Fair use is seen as part of the structure of copyright. And the Supreme Court has said several times that it wouldn't be constitutional to have a copyright law without a fair use standard. So fair use does a lot more than that, and actually that's one of the things that I'm writing on right now, is how to understand fair use not as a narrow exception, but as something that's built into the structure of copyright as a grant of uses, not to the author, but to the public.
So we've recently conducted a research here on fan fiction.
Yes.
So we sort of try to understand who the fan fiction writers in Brazil are and what kind of work they do. Would you say fair use is a good defense for fan fiction?
Well, it's hard to know in any case because there's no mathematical formula. Traditionally, most researchers in the United States that write about fair use assume that the reason we have a fair use defense is because of transaction costs, to make sure that in those cases where we wouldn't expect it to be worthwhile for the author and the user to bargain, we'll let the user get away with it. And so in those cases, according to the transaction cost theory, if it's popular fan fiction, then that shouldn't be considered to be fair use, because fair use is really about very small uses. The standard that's used by the courts these days is whether it's transformative, and so the fan fiction to be good fair use would have to be very far away from what the original is and appeal to a very different market. I would guess that in most cases, again, this would not be the case. In most cases, the fan fiction is appealing to the same audience as the original work does in the same kind of market. Now, in my article, I would argue a different way of looking at fair use. What we're really trying to do is find fair uses where there's a large number of the amount of the public that enjoys the product of the use, that is not the user himself. And that would mean that fan fiction actually would be a very good example of fair use, because the author of the fan fiction is producing good for a very large number of people.
And how do judges weigh the four factors? I mean, do they all have to be present in order for a judge to consider such work a fan fiction? Or can one factor weigh more than another? So
this is the very frustrating part of fair use, and this is the reason that one has to be very cautious in adopting this kind of law, because it doesn't give very clear guidelines. So it's possible that the four factors, some will weigh in favor of the user and some will weigh in favor of the author, and the court will decide that nevertheless it's fair use or it's not. And courts are not always consistent in the way that they view its importance. Some are very interested in the effect on the market. Some are very interested in the purpose of the use. I, for example, am very interested in the purpose of the use. Some are very interested in the amount that is taken. It's very hard to predict these cases, and that's if there's something that people don't like about fair use, that's probably it. It's very vague and difficult to apply.
Okay, so it's a good defense, but it's not a defense that will guarantee you.
There's no guarantees in fair use, no.
Okay, I have one last question regarding
Please.
fair use. I've recently talked to someone in South Africa who told me that because the country is not big on litigation, then maybe fair use isn't that great of a solution, because fair use really works if people are litigating and testing it in court. How would you see that argument?
That's an interesting observation, but I'm not sure it's correct, and I'll tell you why. Fair use actually works where the user starts doing it and waits to be sued. And so I'll give you an example of a recent fair use case. It involved Google, and Google had a project it calls Google Books, and it scanned millions and millions of books without permission, and it just waited until it got taken into court, until all the authors sued Google, and they did, and so now we're in, I think, the 5th year of litigation, and eventually it will be resolved. But if no one wanted to sue, then Google would just go ahead and use the books. The way fair use works is the user starts by using it. The user doesn't start by going into court. And so it may actually be that reluctance to litigate will create more fair use rather than less. It will actually encourage people to go do things, and they won't have to worry about ending up in court. My guess would be that's the way it would more likely work.
But then, of course, if you're Google, even if your pockets are deep enough, you're not that worried about litigation.
Google has no fear of going into a court, whereas the author of fan fiction probably does. But again, the less likelihood, the likelihood of litigation, the more the user should feel comfortable starting without permission.
And our research did look into lawsuits regarding fan fiction in Brazil over the past 10 years, and we were unable to find any. So there you go. There's a good example.
Really? Okay.
Of how
well, there you go.
not really being sued. Not that we do have a fair use like clause, not yet.
Right.
But there's an area where people are not suing. Right?
Where people don't sue, that's where the users go ahead and do what they like.
Okay. Well, that was very enlightening. Thank you so much for talking to us about such an interesting topic.
Thank you for talking to me, and thank you for having me.
You're welcome.